Hello, this is another video about law and another video where I look at a case I found interesting. The case I'm going to look at in this video is called, get ready for it, this is a really long case name, Express and Echo Publications Limited versus Tanton. For my own sake and to stop it from getting really repetitive, I'm just going to call them Express and Echo because it's easier, and this case happened in 1999. The reason I'm looking at this case is because it comes from one of my favourite areas of law, at least one of my favourite areas of law that I've looked at, having not done a law degree. That's something I should have said at the start actually. I have no actual legal education, so just this is for a bit of fun really. If you're interested in law, it might be interesting. Anyway, this comes from employment law, and I love employment law because it is something that almost everyone will have to deal with at some point in their life. And amazingly, it's something that almost everyone has no idea about. It's something which is really quite political, and it can tell you a lot about the political climate of any given time. And I came across this case in particular while reading a journalistic article about must have been like 0 hours contracts or something like that. But anyway, we have in employment law this very important dispute, and it's constantly coming up, and it's the dispute of being a worker versus an employee. If you read the news a lot, at the time of recording this, a couple of weeks ago, there was a huge decision to say that Uber drivers were entitled to, I believe it was sick pay, making them workers instead of contractors. That's something which is emerging more now because we have what is called a gig economy. And that might be the topic for another video, but in short, a gig economy is an economy where I can jump on my bike and become a Deliveroo driver and make some quick money without any real legal stuff going on. But let's look at this case in particular, because this is a bit older. This is way before the gig economy, and it's all about a guy called Tanton. He worked for Express and Echo until 1995, and he's made redundant. However, in August of that year, they decided to take him on again as in a self-employed condition, I guess, right? So he was self-employed, but he was a worker for Express and Echo. What I've just said there actually is conflicting. He was self-employed, he wasn't a worker. We say worker a lot in the English language, but in legal terms it actually means something which I'll go on to talk about in a sec. Having worked for, or done work for, Express and Echo for a little while, in January of '96 he was given a contract which outlined what he would do for the rest of his time as a worker for Express and Echo. He decided against signing it, but he basically worked in accordance with the contract. So for all intents and purposes, he basically was under contract, except he didn't sign it. This isn't a massive, or at least the courts didn't see this as massive, because he worked under the conditions of the contract, so it doesn't affect our case that much. But these are some of the considerations we need to consider about Tanton's working relationship with Express and Echo. So he worked as a driver. That might have been a good thing to say at the start, but yeah, he worked as a driver. I believe it was a delivery driver, I'm not sure. He was paid a fixed rate for each journey. The uniform of vehicle was provided to him by Express and Echo, which I'll come on to in a sec. He was paid a fixed fee per journey. He didn't have any sick or holiday pay. This was in some part because he didn't claim any sick or holiday pay, he just went to work every day. The question then becomes, well, if he did try and get sick and holiday pay, what would happen there? But you know, he was in charge of maintaining the vehicle, so washing it, making sure it doesn't break down, that kind of stuff. Importantly, in his contract, there was something called a substitution clause. What that means is, let's say you hire me to paint your house, which would be an awful decision on your part because I can't paint houses very well, but regardless, let's say you hired me to do that, and I'm due to paint it on the 12th of June, but for whatever reason I can't paint your house. But because we agreed this, and because you're going to pay me, I have the right to get someone else to do the job at my own expense. So whatever happens, someone's going to paint your house, it just might not be me. This was a clause in Mr. Tanton's contract, and it's very, very important. It's called the Substitution Clause. I spoke very briefly about this idea of the worker versus the employee. These are the two main classifications of people who do jobs in the UK. Obviously they're self-employed, but we're not going to look at that too much. And so I guess the better thing to say would be that these are the two classifications of people who are employed by someone other than themselves. So you've got the worker and the employee. If you ask most people on the street, they won't be able to tell you the difference. In fact, they'll probably suggest that they're both exactly the same thing. And they're kind of right, because all employees are workers, but not all workers are employees. Okay? Workers have the right to subcontract work, which is kind of like the substitution clause. So, again, if you hire me to paint your house, I can then pay someone else to hold a ladder or something like that. This isn't really a thing with employees. You can't subcontract your own work. If you're employed by someone to do a job, you must do that job, otherwise that's a breach of your contract, so no go. Workers are obviously entitled to the national minimum wage. They're entitled to rest breaks. You're not allowed to discriminate them against for age or disability or sex or race or whatever. And they have a minimum level of leave that they're able to take. Employees, on the other hand, have much more rights. So they have the right to sick and maternity pay. They have, and also the thing is with maternity or paternity pay, you can't sack someone for going on maternity leave, whereas workers don't have that right. They have protection against unfair dismissal. You can't just sack an employee because you feel like it. You need to have a valid reason, and if you don't have a valid reason, you best believe that they're going to take you to court and take a lot of your money. And yeah, stuff like maternity pay. But the employees have so much more rights than workers. You'll never really find a worker who's paying into their company's pension fund. Employees tend to have much more protection over the hours they work, that kind of stuff. So you've got this more casual worker relationship on the side of the worker, and you've got this more structured relationship on the side of the employee. It's obviously much more desirable to be an employee because you get more rights, and it's just generally better in the long run. In the long run, however, this isn't the case in every relationship. Mr. Tanton went to court to see whether or not he was an employee. This was a dispute they had over whether or not he was an employee between Express and Echo and Tanton. And there were two rulings. The first was done by an employment appeal tribunal, which is just a workers' tribunal essentially. It's not legal in the strict sense. It's like it's a civil. I need to be careful because all of these are civil, but anyway, so there was an industrial tribunal, and they ruled that because Express and Echo had such a strong amount of control over the working relationship, such as the fixture, such as the uniform, this was seen to constitute an employee relationship, employer-employee relationship. There wasn't this kind of relationship where Express and Echo just said to Tanton, you do what you want, as long as the job gets done, you get paid. No, there was this very strict control, and that is something generally synonymous with the employee-employer relationship. So Tanton was very happy, but of course Express and Echo weren't. And being a large corporation, or being a company I guess, large or otherwise, they had significantly more money than Tanton. They decided to push to the Court of Appeal. This is a very good decision for them because it turned out that the Court of Appeal disagreed entirely with the decision made by the Employment Tribunal. They decided that Tanton was certainly not a worker because of this contract in his clause, because of the substitution contract. clause even. It doesn't matter that it wasn't used, because it wasn't used at all. Tanton never decided to let someone else do his job, but because it was in the contract, they ruled that he was not an employee. This is problematic, at least for me, in my opinion, because if you were to walk down the high street, for example, while workers and employees alike are on their breaks, and you would say to them, excuse me, do you have a substitution clause in your contract? They would look at you like you're not speaking English, because people don't read their contracts, really, for the most part. And this kind of thing really does favour the employer, because employers almost always have more money than their individual employees or workers, and so they're almost certainly more likely to have more access to legal advice. They're almost certainly more likely to be able to put in things like substitution clauses with the knowledge that they can actually bound people to worker employment relationships. So what I'm trying to say is, this, in my opinion, is an easy way of depriving employees of their rights. Potentially. See, it's the unfair dismissal, which is the massive benefit of being an employee. And what worries me is that if people don't read their contracts and employers continue to put in these clauses, then there could be massive issues for people being unfairly dismissed and having very little legal protection. Of course, employment law has progressed since this ruling, and in fact, substitution clauses hold a lot less weight than they did 17 years ago. But looking at this case in isolation, it favoured contractual realities over actual workplace realities, and this is something we get to look at in employment law. I hope this video has been useful, and there have been bits where I've gotten a bit jumbled up, but I think when you look at the facts of this case, it tells you that employment law is incredibly interesting because it's just got so much relevance in all of our lives. It can mean the difference between being made redundant and having nothing, and being made redundant and having enough money to tide you over until you get your next job. Employment law is something I hope you might want to go and study in the future. I certainly do. And I'm probably going to do more videos on this topic if this one does well. To show me that you think I should do more videos on employment law, please like the video. If you dislike the video, feel free to dislike it. And subscribe if you want to see more of my content. I hope to see you again next time.